Okay, welcome today again. Thank you for coming. We continue with our class. Yeah, hola Jacob, thank you. Greetings, thank you. We continue with our class today. We continue with the class today. I don't know whether you're hearing me now, Jle, Dickerson. We starting now. I think the audio is all right. I was getting set. If you are not receiving me, then you can put it in the chat. You can just comment there. I will see it. If there is any problem that you are observing. So today we continue with the course Introduction to the Criminal Justice System. Introduction to Criminal Justice is an introductory course for criminal justice practitioners. It is intended to prepare students of criminal justice, prepare practitioners who work in the criminal justice system to understand how the criminal justice system works. Okay, colleague. And so we continue today. Let us try to continue with the subject, specifically the criminal justice system. So now we call it the criminal justice highway. So let's proceed with the system. This is where we started initially, the definition. We went to the nature of crime. Classification of crimes. Search and seizure. We concluded that. The petition for the rate of search and seizure, the elements. We concluded that. For you as criminal justice students. We talk about the definition of crimes. We talk about the various kinds of crimes. Crime mala politica, crime mala sin, classification of crimes, warrant, probable cause, requirements of the rate of search and seizure of our warrant in order to arrest, the law, what the definition of law is. We talk about the various classification of law. We continue with that classification of crimes, and so today we continue with the components of the criminal justice system. There are three major components of the criminal justice system. These three major components are the police, the courts, and the corrections. When we say the courts, we are not concerned with the other courts, the labor code, civil law code, domestic relations code, tax code, probate code, debt code. These are not the codes we are concerned about when it comes to criminal justice, especially when we discussing the three major components of the criminal justice system. The three major components. Let me be slow. The three major components of the criminal justice system are the police, which is the input component of the criminal justice system. Then we have the courts. The courts are responsible to adjudicate and determine guilt in criminal cases. The correctional component, which we call the corrections, comprises the imprisonment and rehabilitation. So we call that the jail and the prison. These are facilities that fall under the correctional component of the criminal justice system. So the input component of the criminal justice system is the police. In criminal justice, when we say the police, it does not necessarily mean that it is only the Liberian National Police. speaking from the Liberian context, it means all law enforcement agencies with specific and specialized law enforcement functions in order to maintain the arena of social control. That's why we call police. So in the definition of the Liberian criminal justice system, we have the LNP, the Liberian National Police. It has specific statutory responsibility. And that responsibility is a law enforcement function, but it is specialized. Then you have the Liberian Drug Enforcement Agency. It is also a police component. It is also a police institution by the definition of criminal justice. It has specialized law enforcement functions that relate to what? Drugs law. Drugs law. Then you have the EPS, we used to call the SSS, the triple S. The triple S is also a law enforcement agency. It is a police agency, but it has a specialized statutory function that is responsible to take care of the VRP, the president, the vice president, and all other persons that the president will also define or designate as VRPs. They are responsible to maintain the personal protection and safety of the president and other VRPs. Specialized function. Then you have the NSA. It is a police institution with specific statutory functions that are defined by law. The NSA, which specifically has to do with intelligence, and they report only to the president. They report to no one. They take instructions from no one besides the president. And their operations are confidential. From there, you have the Liberian Fire Service. It is also a law enforcement agency. It's a police institution. And has specialized functions in terms of what? Fire regulations and safety. You have also the Liberian Immigration. Immigration. They are responsible for the enforcement of the immigration law as well as naturalization. Those are specialized police functions. And we can also say, to some extent, we can also say that the Liberian Anti-Corruption Commission is also a police institution to some extent because it has law enforcement functions, meaning it can investigate, it can arrest, and it can prosecute. It can investigate certain kinds of crimes. And so long as it has that statutory responsibility, police function is also a police entity. Institutions, well, when you have that kind of function. Then the private security agencies are also police agencies, but they have limited law enforcement functions, police functions, in terms of plain protection, access control procedure. And they can arrest on plain view when they see somebody committing a crime in their plain protection area and turn it over to the agency that has responsibility to conduct criminal investigation. Oh man, I talk too much today. Just a minute. Let me drink. Thank you. So these are law enforcement agencies under the definition of law enforcement in criminal justice. Police institutions with specialized functions defined by law. The legislature passed laws to make them special function. Then the courts. When we talk about the courts, we talk about the criminal courts. When we talk about the courts, we mean the criminal courts. What are those criminal courts? You talk about, like for Monserrado County, it means criminal, the first judicial circuit criminal assassin, A, B, C, D, and E for Monserrado County. These are the courts that have criminal jurisdiction to hear criminal cases in the criminal justice system, as well as the magisterial courts, or limited authority with specific minor offenses defined by law. Then the circuit courts in all of the counties have criminal department and jurisdiction based on term. They can also hear civil matters based on particular term. Like for now, the circuit courts have criminal jurisdiction, so they are in the criminal section and they're hearing criminal cases. All of the circuit courts in the counties. When the time comes for them to hear civil cases, then they can go into that trial jurisdiction, also to hear civil cases. They do. So normally, most of the time, that's what happens. Then you come to the third component, which is corrections. When you hear corrections, it means not only the prison institutions, but jail. All the jails also are correctional facilities. They are correctional institutions. They keep people who have been convicted for minor offenses, where the punishment of imprisonment will not be more than 1 year. Unfortunately, it's very bad. I'm observing that the network is bad. The network is fluctuating. Yeah, I'm observing that. So, please bear with me. So let's go to the next. Today we will start with the criminal justice process. The criminal justice process begins with the arrest. The arrest of a crime. The arrest. What does that mean? When a crime is committed, that's how the criminal justice system begins its work. When the crime is committed, the first thing that happens is that there is an arrest. When the person is arrested, sometimes you are arrested either with a warrant or you can be arrested without a warrant, but based on count D, which we call probable cause. Probable cause means those facts and circumstances that are known to a reasonable law enforcement officer that a crime has been committed and that the person to be arrested must have committed the offense. That's what we call probable cause. Facts and circumstances that would be known to a reasonable law enforcement officer that a crime has been committed and that the person to be arrested must have committed the crime. That's what we call probable cause. Also, the person can be arrested because this is how the criminal justice system begins. The highway process starts. I'm speaking figuratively. The arrest can also be made when the crime was committed in plain view, in the officer's plain view. That means the officer saw the crime was committed. The officer witnessed the person committing the crime. In their presence, in other words. He heard the crime was committed. He smelled the crime. He saw the crime. How can he smell the crime? He smells the crime when he observes that while he was sitting somewhere, he smelled marijuana coming, the scent and the smoke coming from a particular room. It means he smells the crime. Another one is he hears the crime. For instance, he's outside, he heard a woman screaming, the crime. If he hears the crime, meaning that the woman was screaming, the officer can effect an arrest because he hears the crime. He sees the crime. He saw the man committing the offense. So that is how the criminal justice system starts. The process begins, and the arrest can be made. The next thing is, when the arrest is made, the investigator must first of all conduct a criminal investigation. When the arrest is made, they conduct an investigation. The next thing they will do is that they will book the person. What does it mean when we say book? Anytime a person is arrested, the police will maintain what we call the administrative records of arrest. The administrative records of arrest mean records of arrest. It means that they will take the person's particulars, their name, their address, their year, their date of birth, their place of birth, their address, their father's name, the mother's name, everything, their fingerprint, everything, they will do that. That's what we call booking. That's the next stage. After the arrest, the person is booked. So when you take the administrative records of arrest of the person, taking their fingerprint, photographing them, keeping the records about them, you are booking the person. That's the next stage in the criminal justice process. When the person is booked, the investigation is conducted. If the police believes that there is a probable cause, if the police believes that there is reason to hold this person and to charge them, to send them to court, then they will charge the person. That's the next stage. You are charged. When the man is charged, the man must be taken to court within 48 hours during the arrest, after the person has been taken to custody. Then that brings us to the next stage we call the initial appearance. When the person is taken to court, that stage is called the initial appearance. You bring the person before the court. The judge is there to read the rate to the person, to acknowledge and to find out whether that person before him is the person whose name is on the rate. And then the person will answer to that. When he answers to that, the judge will now inform him of his basic constitutional rights. You are charged for this crime, John Brown. These are your rights under the law. You have the right to a bail if the crime is bailable. You have the right to a lawyer. Do you have a lawyer? The lawyer will make the representation and say, Your Honor, will represent the defendant. And then he appears before the court. He tells the judge or the magistrate. So that is what we call that if the person has any bond to pose in order to be temporarily released or placed under temporary conditional release by the court, then he will post a bond before the court. When he poses the bond, then the judge will approve the bond and allow him to go. In some instances, based on the reputation of the person, the reputation, the integrity of this person in society, the judge does not need to ask or require a bond. Ask a bond to be posted. The judge can release the person on something we call personal recognizance. And say, look, since indeed you are a reputable person in the community and you will not run away, our law in this system operates on what we call the principle of presumption of innocence. You can go home. Now, anytime the case is ready, then you will get the notice of assignment through your lawyer. Or if you choose to be only yourself as a law to represent yourself, then you get a notice from the court. The purpose of these conditional releases is merely to inform the person to be able to be on time in court when the case is heard. It's not to presume that the person is already guilty. Our law operates on the principle of presumption of innocence. Any person who is accused of a crime, that person is presumed innocent by law until a court of competent jurisdiction, either by a jury of his peer find him guilty when the trial had been exhausted and the decision is left with the jury to determine the guilt or innocence of the person after they have retired in their deliberation room. No question who is accused of a crime is presumed guilty of the offense. So, no court of law must presume that this person is already a criminal. So I will not give him a bond. No. Our law operates on the presumption of innocence. You are presumed innocent until the contrary is proven in a criminal trial before a court of competent jurisdiction that will determine that you are guilty. In the absence of that, you are innocent under our laws. That is the criminal justice process. The next thing we need to go forward with is the preliminary examination. You look at a preliminary examination based on request. Now you will ask me, what is meant by preliminary examination? For those of you who are criminal justice students and practitioners, preliminary examination is found in chapter 12 of the Criminal Procedure Law of Liberia, volume 1, title 2. The Criminal Procedure Law of Liberia gives the right only to the defendant to request the magisterial court to conduct a preliminary examination. The only circuit court in Liberia that has the authority to conduct preliminary examination is the Rape Court. The Rape Court, Criminal Code E in Mossoraro County. Or our circuit courts that in the county when they are conducting a trial in a rape case. The defendant in the circuit court can request for preliminary examination in the circuit court. With the exception of that, all other cases that are triable before the various circuit courts, the criminal circuit court, the preliminary examination is only cognizable before the justice of the peace or the magisterial court. Now, what is preliminary examination? Preliminary examination, it is the request that the defendant makes to the magistrate and says the following. He says, Your Honor, let me speak in the lingua franca, the community language. Your Honor, the case that the people say they had against me, accusing me for committing a crime, I want you to examine the evidence that they have. And if you examine the evidence that they have, you will observe that they have no probable cause to hold me to issue the rape. In other words, they have no reason by facts and by law to hold me or to even charge me. That's what we call preliminary examination request. Now, so at that level, the magistrate, because it is a right of the defendant, it's a statutory right of the defendant to make that request to the magistrate, asking the magistrate to conduct a preliminary examination, meaning to evaluate the prosecution evidence and see whether there is any good ground for the prosecution to hold the defendant. So it is chapter 12, section 12.2 of the Criminal Procedure Law that is evoked by the defendant. When the defendant makes that request, then the hearing will start. The magistrate will conduct the hearing. Although the magistrate does not have trial jurisdictional authority, but he has preliminary examination authority to examine the evidence on the face. So the prosecution will be the only party that will produce evidence during the preliminary examination. When the prosecution produces its evidence, the prosecution will in fact start now to bring witnesses to testify why they're holding the defendant, why they charge the defendant. Then the defense counsel will cross-examine those witnesses. But the defense counsel, in that case, cannot produce evidence. No. During preliminary examination, the defense counsel cannot produce evidence. Only the prosecution can produce or evidence to the magistrate. For the magistrate to examine, to believe or to deny or to refute or to say, gentlemen, I don't see any probable cause to hold 8 people. I will dismiss the ring. Or I see probable cause. Let the defendant then go answer in the case above me, in the court above me, in the circuit court, the proper court. That is the essence of preliminary examination. Let's stop there today. Next week, we continue with the criminal justice process. Thanks for watching and good day. Don't forget to subscribe to the YouTube page. Thank you. Good day.